During the summer of 2020, General Paxton's aide was asked to deliver a manila envelope concerning several sheets of paper to Nate Paul at his business in Austin. I want to go back for just a moment to that second request. Not taking a position at all is still a decision because that requester is not going to get the records, not without an appeal. And that appeal actually goes to a district court. That did not happen. The executive staff reasoned and told us they believed that there would be no need to follow up if you already had the information that you were trying to get. Two issues of concern were raised in this particular arena of the open records requests. First is the fact that Attorney General Paxton, the person who's charged with uniformly applying the law of the Public Information Act, was pushing his staff to ignore the law and legal precedent, and that would have thrown all of law enforcement into unsure territory, including his own office, all to obtain the information sought by his friend and political donor, Nate Paul. And secondly, the directing of his office staff to not assist the feds or DPS is not a tenable position for the top law enforcement officer of Texas.
Vice Chair Johnson has a question.
Is there any indication, I know you've talked about this envelope, and in that envelope, staff confirms that it's the unredacted version of the FBI search warrant into Nate Paul?
We don't know what was in that envelope.
Okay. Is there any indication or is there any connection of how Mr. Paul could have gotten access to that information?
We know that the file was delivered to the Attorney General Paxton. We know that he had it for a period of time. We know that during the summer of 2020, an envelope, a manila envelope, was delivered, and we also know that that was the first time the aide had done that.
The aide delivered the manila envelope to who?
To Nate Paul.
So a staff person, so Ken Paxton asked an aide to take a manila envelope and give it to Nate Paul.
That's correct, and it was delivered at his business here in Austin, directly to Nate Paul.
And then after that manila envelope is delivered to Nate Paul's lawyers stop asking for the FBI information into the search warrant.
That's correct. Any other questions concerning open records?
Chairman Longoria.
I may have missed it, but is there any when and where it was dropped off? I guess you mentioned it was Nate Paul's office, but was it like during business hours, Monday through Friday, 8 to 5? Was it on the weekend? I mean, any clarification on that?
All I know, it was during the daytime, and it was to his business.
Okay.
Across from the governor's mansion.
Was this normal activity, or did the staffer think that this was abnormal?
This particular delivery was abnormal enough that it was discussed with his supervisor at the time.
And what happened with that discussion with the supervisor?
It was information that kind of percolated as part of the unusual things that were happening in 2020.
Thank you.
The next item I'm going to discuss concerns the Midi Foundation lawsuit. Under the property code, the legislature provides that state government should aid Texas charitable organizations that are in need. That policy designated the Attorney General shall represent the public interest in charitable organizations and is authorized to act to protect that interest. There's a financial litigation and charitable trust division within the OAG. They received notice of litigation involving nonprofit charitable organizations. And there are attorneys within that division that review the situation for each of those to determine if the charity is capable of handling the lawsuit or if their interests need to be protected. And in those situations, the Office of Attorney General intervenes and assists or supervises. In a typical year, there may be hundreds of notices, and of those, only 24 might warrant the time and investment of the Office of Attorney General. The Roy F. and Joanne Cole Midi Foundation was created in 1998 to promote historical, cultural, educational, and family activities in and around the Dean Porter Park in Brownsville. They initially awarded cash scholarships to high school graduates to go on to college expenses. They have built a library and most recently have become involved in developing the Brownsville Cultural District. In 2009, the OAG had been involved in an investigation concerning the Midi Foundation when it learned that one of its board members had been arrested for a second possession of controlled substance case. Part of their investigation uncovered several financial improprieties, and that board member was removed. Since then, there have been no issues with the Midi Foundation that anyone was aware of. In 2011, the Midi Foundation invested about $3 million with World Class Holdings, a company owned by Nate Paul. And I refer to it as one. It's actually multiple entities and subgroups within that. They were involved as limited partners. The commercial properties involved in the partnership had been scheduled to be sold in the 2010s. That failed to happen. When the Midi Foundation asked to view the partnership books, which they were legally entitled to do, Nate Paul refused. Litigation began in December of 2018. There eventually was an agreed settlement worked out through arbitration that Paul would buy the Midi Foundation out for $10.5 million with a funding date of August 20th, 2019. 4 days before that funding date is when the FBI executed the search warrants at Nate Paul's businesses and his home. Paul ultimately defaulted on that settlement. It did not happen. In December of 2019, the Midi Foundation notified the Attorney General's office of the pending lawsuit. In January of 2020, those attorneys within that charitable division, the Charitable Trust Division, looked at that lawsuit and determined that there was no need for their involvement. On January 31st of 2020, they filed a written notice with the district court that was hearing that lawsuit, that they were not going to be involved. Early in 2020, Attorney General Paxton asked an executive staff member to evaluate that Midi Foundation and World Class Holdings situation to see if there should be an intervention. At that point, that executive recognized that World Class Holdings belonged to Nate Paul. He spoke with Josh Godby, who was the division chief at that time of the Financial Litigation and Charitable Trust Division. They both looked at the file. Godby learned that the Department of Justice was investigating world-class entities and that they considered the Midi Foundation to be the victim in their scenario. Godby and the executive staffer determined, again, that there was no need for OAG involvement. They felt that the charity was doing everything that we as government supervisors would ask them to do. There was nothing more that the Office of Attorney General could do for them. Their interests were being protected. They had hired well-qualified attorneys for their lawsuit. General Paxton disagreed with that assessment. He insisted on intervening in the lawsuit. Godby was instructed to intervene, and the executive and Godby determined that the way they would present that was to facilitate a settlement. In other words, the OAG's involvement was to help Midi facilitate a settlement. That petition in intervention, that formal notice to the district court, was filed on June 8th of 2020. Until this point, Attorney General Paxton had never gotten involved to this degree in any of Godby's cases. The executive staff member was extremely concerned because this was the second incident of General Paxton pushing to do something against the recommendations of highly qualified people, all for the benefit of Nate Paul. The executive staff member eventually was moved out of that position. The issue fell into the lap of Blake Brickman. Blake Brickman also agreed that there was no need for OAG involvement in this situation. But on July 6, 2020, while General Paxton was on vacation, he called Blake Brickman, who then was the Deputy AG for Policy and Strategy, and asked him to take a look at that lawsuit. Brickman learned at that point that the intervention had already happened and that the Attorney General had directed that it be done. Brickman knew at that point that Nate Paul was a donor. He was also aware about the federal investigation. He advised General Paxton to have nothing to do with Nate Paul and strongly advised against the OAG getting involved in this lawsuit, in fact, in anything concerning Nate Paul's business. General Paxton, in return, told Brickman that he believed Paul was wronged by law enforcement, specifically, again, going back to that search warrant. Brickman told him that there are many avenues for a citizen who feels that they've been wronged by law enforcement to go to attempt to have their hearing and get things done, that the OAG's office was not the proper place for that. Brickman also pointed out to Attorney General Paxton the various bankruptcies that Nate Paul was involved in and strongly advised that General Paxton not involve the office in Nate Paul's lawsuit. Approximately 2 weeks later, 4 senior executive staff members of the Office of Attorney General met with General Paxton, who was insisting at that point that he appear in district court to personally argue the Midi lawsuit. According to these executive staff members, General Paxton never argued in court. He left the courtroom work to his litigation experts. There were concerns at this point in time. COVID was a high priority. There was a high influx of COVID-related litigation that the OAG was attempting to deal with. And yet these staffers saw General Paxton spending resources and time on a charitable case for a man who is under federal investigation who had defaulted on the previous settlement when the charity itself had the lawsuit well in hand. Joshua Godbee not only filed the intervention at the direction of General Paxton, he also complied with General Paxton's order to file a motion to stay the pending lawsuit to force the parties into mediation. That motion basically holds and stops the lawsuit. Nothing further concerning the litigation in the district court would go forward until mediation had happened. Ray Chester, who's the attorney representing the Midi Foundation, said that such a move was highly unusual, as the parties had both gone through arbitration and mediation already at that point. And the Midi Foundation was ready to go to trial to get this thing over with. They had exercised every option that they could at this point to reach a resolution. There is no requirement under the law, and typically litigation doesn't have to stop if you want to go back to mediation. In other words, there's no reason to tell the court everything has to stop, we're going to go mediate. That mediation can happen regardless of the lawsuit. So one is not required for the other. He said the halting of litigation, and this is Ray Chester, he said the halting of litigation hurt the Midi Foundation, the entity that the Office of Attorney General Paxton claimed to be assisting. Ray Chester then described ominous pressure, his words, from McCarty. McCarty is Josh Godbee's supervisor. He's the Deputy Attorney General for Civil Litigation. Both McCarty and Sheena Paul, this is Nate Paul's sister, who's an attorney who was involved with this lawsuit. Together, McCarty, an employee of the OAG, and Nate Paul's attorney, his sister, pressured Chester to settle even before the mediation began. The Midi Foundation was being offered less than half of what the original settlement had been that they had reached under mediation earlier. The Midi board unanimously rejected that offer.
Ms. Buse, I want to interrupt you briefly. I'm wrapping my head around that. So you have told us that, and we are all familiar with the fact that state policy for the state of Texas in regards to charities is to look out for their best interests. We treat them as something that is benevolent, and they're out there to help many different causes. And when they get into a lawsuit, there's actually a framework in place where the OAG is notified of that lawsuit, and they determine whether or not this charity needs assistance for the benefit of the charity. And what you have just told us is not only was policy not followed, but then the Attorney General's office got involved and immediately worked against the charity to try to mediate something for less than half of what was already mediated.
That is what the evidence shows.
And when you say Ray Chester, I want to clarify, that is the attorney that was actively involved in the litigation for this nonprofit organization.
Ray Chester represented the Midi Foundation for this lawsuit. That's correct.
Thank you. Chairman Longoria.
Quick question. Was there a docket control order in place already on this case?
I don't know about a docket control order. I know it had been a very lengthy process, and there had been multiple lawsuits, multiple appeals, so it had been going on for a long time.
Okay.
Please continue.
General Paxton told Godby that he believed World Class was more in the right than his staff was telling him. He expressed frustration with the fact that he thought investors were using litigation as their first response when their investments don't turn out the way they wanted. And he said he too had been looked at by the Securities Board. The reality of this particular situation was that Nate Paul and World Class were stalling. And again, Ray Chester, the attorney for Midi, felt very strongly about that. They were stalling any settlement and would drag things out as long as they could. At the ordered mediation, Nate Paul refused to participate. He refused to allow his attorney to participate in negotiations. And the negotiations ended up being between the Office of the Attorney General and the Midi Foundation. They should have been on the same side. The Midi Foundation received no benefit from the intervention of the OAG, and the involvement of the OAG ordered by Paxton solely benefited Nate Paul.
And just to come back to it, the feds and Godby and others identified the charity as the alleged victim in this matter. They also identified the fact that they had the resources to litigate as an investor with this series of companies, and yet the OAG showed up and essentially was adverse to them at mediation.
That's correct.
That was forced by the OAG. Thank you.
Correct. The OAG withdrew from this litigation in October of 2020, immediately before the whistleblower letter became public. As part of the ongoing trial preparations, so these are things that are happening after that, so the litigation is now proceeding, Nate Paul was deposed by the Midi Foundation attorney. It was established at that time that Attorney General Paxton had recommended and Paul had hired a woman who was identified by the executive staff as being General Paxton's mistress. Nate Paul was later held in contempt concerning this lawsuit and sentenced to a jail sentence for violating the court's order of financial disclosure, as well as court-imposed spending limits were being violated, and lying under oath about that. The Midi Foundation ultimately went to trial, and Ray Chester advised us that they cleared $21 million from the forced sale of their properties. You'll recall the $25,000 Nate Paul donation to Ken Paxton's campaign. That occurred in October of 2019. I mention it again in this context because the timing of it would have been when the World Class Holdings and the Midi Foundation were heading towards litigation. General Paxton, in this instance, charged with protecting Texas charitable foundations, disregarded his duty and improperly used his office, his staff, his resources to the detriment of the Midi Foundation and to the benefit of a single person, Nate Paul.
Speaker Guerin.
Mr. Chairman, thank you. When y'all were looking at this, obviously the $25,000 contribution to the Paxton campaign came up. Is that an unusual amount from Mr. Paul, or did y'all look into his political contributions to other people?
He made multiple contributions to a variety of people. And I think I'll just leave it at that. There were smaller donations that we saw.
Did you see any in the 25,000 and up range, which is that obviously is a large contribution?
I don't recall at this moment.
All right, thank you, ma'am.
I do recall a lot of smaller donations being made.
All right, thank you.
Good morning. I'm going to pick up from here and discuss two issues with y'all. First of which is what we'll refer to as the Office of the Attorney General informal opinion letter regarding foreclosure sales. The second of which will be what we have referred to as the Brandon Kamek investigation. So I'd first like to start with the informal opinion letter. Please keep in mind that during the time at issue here, COVID-19 guidance was being issued by government entities, and the consistent message from the state of Texas was to achieve the least restrictive means to combat COVID while still, quote unquote, opening Texas. Late on Friday, July 31st, 2020, General Paxton contacted a senior staff member to research whether in-person foreclosure sales violated COVID restrictions. General Paxton wanted the opinion done by the end of the weekend, which was extremely abnormal. In other words, he wanted this opinion drafted and put out within 2 days. When asked if anybody had made the request, General Paxton provided a phone number for a person. This also violated procedure, codified procedure, because any request for opinion must be made in writing. It cannot be made orally, and it can only be made by certain individuals, certain qualified individuals. The senior staff member took it upon himself to contact the individual who General Paxton provided a phone number for. That person was completely unfamiliar with the matter or the issue. As there was no official requester for this opinion, it is our understanding, based on the investigation, that a staff member reached out to Senator Brian Hughes and asked him to serve as the official requester. This, however, circumvents the reason for the requirement that an official request be made and that it be made in writing. We also learned that this was done in name only and in appearance only, and that the information was generated internally from the Office of the Attorney General. In other words, the request was generated from the Office of the Attorney General rather than by an official requester. The Deputy Attorney General for Legal Counsel, Mr. Vassar, was tasked with working up an opinion letter as to whether or not public foreclosure sales constituted gatherings for the purposes of COVID regulations then in place. Mr. Vassar worked with another senior staff member and determined that the foreclosure sales could proceed and did not violate COVID restrictions. Vassar's opinion was shared with others in the staff who agreed with him. Soon thereafter, Mr. Vassar was instructed that General Paxton wanted to find a way to stop the foreclosure sales and that the opinion needed to change. Mr. Vassar did as he was instructed and reworked the opinion. In the early morning hours, approximately 1 to 2 a.m. on Sunday, August 2nd, 2020, the Office of the Attorney General issued an informal opinion letter advising that public foreclosure sales are subject to the 10-person attendance limits, and therefore holding one would not comply with the property code requirement for a public sale.
Mr. Donnelly, I want to interrupt you real quick. So I think we're all familiar with the fact that qualified requesters can seek an AG opinion. And that can come from different agencies, that can come from prosecutors around the state of Texas, that can come from chairs of legislative committees. And how long does that typically, that time frame, what is the statutory time frame for when that occurs, from the request to an opinion being issued?
Yes, Chairman. Normally, not normally, the process is allowed 180 days.
180 days. So we're talking a long time, 6 months.
That's correct.
And what you just told us occurred in how many days?
2 days.
In 2 days' time over the weekend, and you said it was what, 1 a.m. on a Sunday morning, or essentially a Monday morning?
Into Sunday morning, correct, Your Honor. Excuse me, Your Honor, Chairman Murr.
So,
Force of habit.
no problem. So we're talking about the fact of a request for turning around an attorney general opinion within hours.
That's a fair statement, Chairman, and I'll also cover in my remarks here a little bit more about how the procedure normally unfolds.
Please do, and then Chairman Longoria has a question.
So the request came in on the 1st of July, right?
The request came in on July 31st.
July 31st.
Correct.
And the opinion was issued out?
On the 2nd of August.
2nd of August.
In the very first hours of the 2nd of August.
And when would have been the first Tuesday of the month of August?
It would have been the 4th then.
Okay, all right.
And an excellent point, because those public foreclosure sales are held on the first
Tuesday of the month. That's what I was kind of...
That is correct.
Okay.
Correct.
Please proceed.
Thank you. General Paxton, upon learning of, upon being informed of the final opinion letter that was to issue, requested that a press release issue, but was ultimately dissuaded by his staff and was told that that was not a good idea. Now, as we've discussed here briefly, and as your questions have intimated, there is a process in place for opinion letters, and that process was completely thwarted here. The only logical reason that the whistleblowers and the evidence would show was that General Paxton wanted the opinion letter complete before the foreclosure sale of certain properties related to Nate Paul entities occurred that following Tuesday. The things that stood out as conflicting with established process and procedures are, one, the request ostensibly came from a phone call, and as we mentioned, there's a requirement that it be in writing and be by an authorized person. Again, there was no documented requester. The opinion had no RQ number, in other words, no tracking number, so there was no way to internally track both from the original request to the final opinion, also extremely abnormal. There was no cover sheet related to the opinion. The Deputy First Assistant and the Deputy First Assistant Attorney General alone signed this opinion letter. Usually, there's a writer who's initially assigned, who signs off. The Opinion Committee Chair signs off. The Deputy Attorney General for Legal Counsel signs off. The First Assistant Attorney General and the Attorney General. Now, mind you, these are not formal signatures that they actually write out, but there are signature blocks from each one of them showing that they would be approved. Those 5 were not present in this case. It was only the First Assistant Attorney General. And of course, as I've mentioned, the speed in which this was turned around was incredibly fast. As I've mentioned, they normally get a request letter and assign it to a writer. They have approximately 180 days to turn around that opinion. Normally, the writer seeks input from other subject matter experts in the area in order to make sure that the opinion that they are turning out is valid, is based on logic, common sense, reason, and the law.
Vice Chair Johnson.
Just to clarify, so there is a finding of a $21 million judgment that is to be executed on behalf of the Midi Foundation. In the same space and time, there is a foreclosure on Nate Paul properties to potentially fund that award. Does Nate Paul use this foreclosure opinion to stop the foreclosure of any of his properties?
Nate Paul, let me clarify a couple things. The properties are Nate Paul controlled entity properties, okay, for which he is the personal guarantor on these 13 properties. There were properties that were set for foreclosure that following Tuesday. This opinion letter was not directly used to stop those foreclosure sales at that moment because Mr. Paul proceeded into bankruptcy proceedings related to those properties. During the month of August 2020, the opinion letter was used by Nate Paul attorneys to attempt to stop foreclosures on some 12 to 13 properties.
Additional properties.
That's correct.
So this opinion letter that effectively is Ken Paxton at a time using COVID as an excuse to say you can't have 10 people outdoors, we're going to shut that down, in contradiction to every other statement that was being made statewide about keeping businesses and things open during COVID.
That's our understanding.
A complete and total contradiction of state policy and a complete violation of the processes that is to be followed and issued within 2 days solely to the benefit of Nate Paul.
That's our understanding.
And I believe that Mr. Spiller has a question, but before he does that, you said that this was an informal opinion or something similar to that. Is that right?
That is correct.
So if I go to the AG's website right now, which I'm familiar enough that I can go and search for Attorney General opinions because they provide guidance, and not necessarily the letter of the law, but they provide guidance and can be relied upon by local governmental entities, for example. Could I find that informal opinion on their website right now?
You could not, Chairman. Additionally, you could not find the original request reference back to my comment about the lack of an RQ tracking number.
I could not find the original request, and I could not find the informal opinion.
That's correct.
Okay. Mr. Spiller.
Thank you, Mr. Chairman, and I appreciate that because that was what I was going to follow up on as well. So what you're telling us back previously, we've already dealt with this issue with a no decision rendering on the prior thing, which is complete distancing of the protocols, and I've dealt with AG opinions for 35 years. I've never heard of a no decision, and now we get into a situation completely, I guess this is unprecedented, to have not even a request, not even a written request, but also have an informal opinion where that opinion is not even available, and it's used to stop multiple foreclosures. Were these foreclosures tied into this other judgment or other debt-related issues unrelated?
I believe that they were different. As our investigation reveals, they were different properties.
Okay, and were they, if you know, were those non-judicial foreclosures scheduled, or were they through a judicial proceeding, or do we not know that?
I don't know the answer to that at this very moment, but it is information that we've looked into. I just apologize, I don't have that.
That's fine. That's fine. Thank you.
But I'll follow up on Mr. Spiller's questions real quick. This informal Attorney General opinion that contradicted probably a lot of other state policy that you could have outdoor functions continue during COVID restrictions, it was used by Nate Paul for his benefit.
That is correct.
Thank you. Please continue.
And Chairman, as Representative Longoria, and I apologize if you have a question, sir.
Oh, Chairman Longoria?
Go ahead.
As you mentioned, these sales occur monthly. They occur in open spaces generally in the steps of the courthouse. There are a number of foreclosure sales that occur throughout the state regularly and are planned on this first Tuesday of the month. So it had the potential of impacting a substantial number of foreclosures.
So the ripple effects, I guess is what you're saying, is while this was used for Nate Paul's personal benefit at the direct action of Mr. Paxton, this rippled through the entire state of Texas and affected foreclosure sales on courthouse steps all across 254 counties potentially.
I'm always careful with my words. I don't want to testify that occurred, but I would say that had the possibility of
There were
occurring.
certainly effects. Understand.
I wanted to ask, how many COVID-related opinions were issued out by the Attorney General during COVID? Do you know?
I apologize. I don't have that number,
Okay.
but I believe a substantial amount.
A substantial amount. Do you know what the turnaround time on those opinions was?
What I can say, sir, is that keeping in mind the abnormal speed in which this decision was rendered, the normal process of taking up to 180 days as allowed was commonplace, was the norm, and was the standard practice.
Okay. My other question is, did you see or find by any chance, did Nate Paul or any of his entities try, filing TROs or anything to stop the sale prior to the opinion?
I don't know the answer to that as far as prior to the opinion. after the opinion, the opinion was
But the
was
basis
used
for
as,
the stopping, yes, but I wanted to see if anything was done prior to
I
that.
apologize, I don't have that.
May I interrupt, excuse me, may I interrupt briefly? I think Mr. Donnelly said this correctly a moment ago, but I wanted to clarify just.
Can you use the microphone so we can all
Yes,
hear it?
thank you. I believe that Mr. Donnelly said this correctly a moment ago, but I'd like to clarify just to ensure. The letter opinion was signed by Ryan Banger. All of the other things that were just explained to you in terms of what was lacking are still accurate, but it was Ryan Banger who signed it. And then the second thing I would clarify is that we cannot establish that the letter was offered 13 times. What we can establish is that he had 13 properties in foreclosure at the time. Thank you.
Speaker Guerin, did you have a question?
Yes, thank you, Mr. Chairman. Mr. Donnelly, was this informal, I guess, informal opinion, is that a good way to describe this opinion?
Informal Attorney General opinion letter.
Was it used by Mr. Paul's attorneys to stop other foreclosures, which would have happened the first Tuesday in September? Or do you know?
They were used in subsequent, the opinion was used in subsequent filings by Nate Paul's attorneys to attempt to stop action.
After the first Tuesday in August?
Correct.
So looking forward in September, October, November, something like that?
Correct, for future actions.
Okay. Thank you, sir.
Any other questions I can answer on that?
No, please proceed.
So again, just to recap, senior staff members learned that Nate Paul had 13 properties set for foreclosure in that August 2020 timeframe, and that the whistleblowers believe that the only logical reason was that General Paxton wanted the opinion complete before the foreclosure sale related to those Nate Paul-controlled entity properties. During our inquiry, we were able to establish that those Nate Paul-controlled entities had properties for which Nate Paul, as I mentioned, was the personal guarantor that were slated for foreclosure sale the Tuesday following the Office of Attorney General informal opinion, and that Nate Paul, in a deposition on January 19th, 2021, admitted in a request for production or request for answer while under oath and while represented by counsel that one or more representatives from World Class contacted the Attorney General regarding foreclosure sales in Texas before the issuance of the Attorney General opinion. When specifically asked, did you, Nate Paul, contact Attorney General Ken Paxton regarding foreclosure sales in Texas before the issuance of the Attorney General letter, his answer was, yes, I had. I had contact with him before that, yes. And when followed up with, to your knowledge, did anyone, again associated with World Class, contact the Attorney General besides you? His answer was no, not that I'm aware of. Are there any questions that I can answer on the foreclosure issue that I haven't already addressed? Thank you. I'll proceed then to what we have referenced as the Kamek investigation. I'd like to begin with the premise that hiring of outside counsel is not a common occurrence at the Attorney General's office, or was not previously a common occurrence. It is almost unheard of in recent memory to hire outside counsel for criminal matters. And this reason, as you can imagine, is quite simple. The Office of the Attorney General employs an impressively credentialed team of criminal assistants, including an entire white-collar criminal division. Those over 800 assistants will often serve as deputized assistant district attorneys who work with local district attorneys' offices, or prosecutors pro tem when a district attorney's office was recused or a judge has made an appointment of that individual for a prosecutor pro tem. In the time frame of May and June of 2020, General Paxton contacted the Travis County District Attorney's Office on behalf of Nate Paul and requested a lunch where Nate Paul will be present in attendance to discuss a complaint. The evidence will show that the Attorney General's level of involvement or interest in a complaint of this size and of this issue is irregular, as is the personal introduction of a complainant to a district attorney's office. In June of 2020, 2 senior staff members with the Travis County District Attorney's Office attended that meeting, that luncheon, and reported back to their elected district attorney that there was no matter, that there was no issue. Yet Nate Paul was insistent, so they proceeded per their protocol to direct him to organizations that might be better equipped to assist, specifically the Office of the Inspector General, the Federal Office of the Inspector General, Civil Rights Divisions at the United States Attorney's Office, and others. Mr. Paul declined. They offered him the opportunity to fill out a complaint form. This is a complaint form which is standard and filled out by anybody who comes into a district attorney's office to complain about a wrong that is committed upon them or some crime that they believe has been committed. It is also assigned by course and conduct an investigation number. This is merely an internal method of documenting the complaint and confers absolutely no special status on that complaint. The forms are a standard way of gathering information regardless of the merits of the claim and are not pursued for reasons such as statute of limitations, lack of credibility, or lack of jurisdiction. Mr. Paul filled out and submitted an initial unsworn written complaint. I emphasize unsworn because it is supposed to be sworn to as a precaution against taking false or vindictive action. This initial request or this initial complaint was not. The Travis County District Attorney's Office was unmoved and found no merit to the complaint, no actionable or credible crime, but feel that because the request came from the Attorney General himself, that they would take the complaint. Travis County District Attorney's Office then formed the opinion that the allegations did not have any merit and that the Attorney General himself had the authority to do his own investigation if desired. So this brings us to the point that at the time that this had been reviewed by the Travis County District Attorney's Office and the time they sent it back, in other words, to the Office of the Attorney General, the District Attorney's Office, Travis County District Attorney's Office, had not recused itself. They did not request assistance. They did not maintain control or management of any investigation or any file or anyone related to Nate Paul after sending an email. They had no investigation.
And why is that significant under Texas law?
That's significant. I apologize.
Just generally, why is that significant under Texas law?
It's significant, Chairman, because the way that I have described previously the Office of the Attorney General, prosecutors, assistant attorney generals getting involved in cases, the deputized DA or the prosecutor pro tem has certain requirements to it. And generally speaking, when a district attorney asks for assistance in a case, in other words, they have a case, they have an investigation, they have a matter that's pending, and they ask for assistance, and they request that assistance from the Office of the Attorney General, they receive what's called an assist, which is in the form of a deputized district attorney. So that individual, I apologize.
Well, and I'll interrupt you. So, and I think the public takes for granted because we don't obviously talk about it, but the state of Texas is set up with a diffused system where our local prosecutors have primacy over criminal cases.
That's correct.
And the Attorney General's office, except in very limited circumstances under state law, does not have any authority in criminal cases unless this request is made.
Correct.
So they are there as a backstop for resources for when a local prosecutor doesn't have those resources.
That's correct.
That's a better way to say that.
That's a fair summary of that. And also, as a deputized DA, they come in to assist on the case. If it is a prosecutor pro tem, again, the district attorney has recused themselves or their office, or a judge has made the appointment of a prosecutor pro tem, and there you take an oath. There is a process involved, and then there is the final option, which is a special prosecutor. When a special prosecutor is invited in by the district attorney has a matter. They keep care, control, and management of that case, and they can hire on any licensed attorney in the state of Texas. But again, it is their case. They're the ones in charge of it. They maintain control and management.
So could I summarize by saying the local prosecutor always has to take some type of action in order for the Attorney General's office to participate, but that is also the explanation of why there are literally hundreds of staff with the OAG that work in various specialties of criminal law.
That is accurate.
Thank you.
So General Paxton assigned senior staff members Mark Penley, who at the time was the Deputy Attorney General for Criminal Justice, and David Maxwell, who was the Director of Law Enforcement, to review the complaint made by Nate Paul sometime around June of 2020. The complaint stemmed from the FBI search warrant, which has already been discussed here. So it stemmed from the FBI search warrant of Nate Paul's home and businesses based on a search warrant that was approved by a federal judge. The Department of Public Safety and the FBI were also involved in the searches and executing the searches. The staff members arranged a meeting with Nate Paul at the Office of the Attorney General. As an underlying issue involved in the federal investigation, there were federal entities who were capable of receiving a complaint regarding the actions of federal agents. As I mentioned before, there's the Federal Office of the Inspector General, FBI Legal, and various other agencies who would have been well equipped to handle these complaints. However, Nate Paul told the staff members that General Paxton had advised him that the Office of the Attorney General could assist. Both Penley and Maxwell explained to General Paxton that there was no evidence of a crime and there was no state interest, yet General Paxton remained critical of their review and decision. As a result of that, the staff members relented and agreed to another meeting with Nate Paul. Nate Paul at this point had failed to disclose the very documents he claimed supported his allegations of tampering by federal entities. Nate Paul did ultimately produce some documents which were presented to Office of Attorney General forensic experts for analysis. Those experts reviewed the documents and concluded that there was no evidence of tampering. General Paxton was informed of this decision and was again warned about Nate Paul, his suspect business dealings, and the dangers of pursuing this issue that Nate Paul has presented. Undeterred, General Paxton set up yet another meeting with senior staff and Nate Paul. General Paxton attended this meeting. The staff members explained that there was no evidence of a crime and that the Office of Attorney General was closing its case. Senior staff had previously notified General Paxton of this decision, and he indicated that they simply needed to tell Nate Paul this. However, at the meeting, both General Paxton and Nate Paul reacted negatively. Nate Paul was so incensed, according to witnesses, that he dressed down the Office of Attorney General senior staff as if they were his own employees. A few weeks later, staff members learned that General Paxton was looking for outside counsel. And keep in mind, the process of hiring outside counsel requires multiple reviews and approvals throughout the upper echelons of the Office of the Attorney General. It's codified at section 402.0212 of the Texas Government Code. And underlying that section is the basic premise that a valid contract for services exists. If anyone along the chain disapproves, the process stops. There is no witness that had memory of General Paxton ever personally hiring outside counsel without following the established procedure. General Paxton vetted two individuals for the outside counsel contract, one with decades of federal and state prosecutorial experience, and one with approximately 5 years' experience as a lawyer and absolutely no prosecutorial resume.
Speaker Guerin has a question.
Thank you, Mr. Chairman. Mr. Donnelly, would you go back through what the normal process is? I want to make sure that all that sunk in.
Of course, the normal process is that a contract is developed. Individuals are vetted for the position. A contract is developed. That contract is supposed to be approved along various chains, up the chain of command within the Attorney General's office. And I apologize.
So it would be highly unusual for it to go directly to the general, is that right?
As I mentioned, it is unheard of in any witness's memory that we spoke to that the Attorney General himself went and created a contract by himself.
Thank you, sir. I appreciate it.
Thank you. So again, Mr. Paxton, General Paxton, chose the latter of those two options, Brandon Kamek, who is a 5-year attorney out of Houston. Through our investigation, we determined that the source of the referral of Brandon Kamek was through Nate Paul.
Would you say that again?
Yes. Our investigation has determined that the source of the referral of Brandon Kamek to be vetted for this position, for this contract, was Nate Paul.
Chairman Longoria has a question.
Thank you, Chairman. Can you explain kind of the connection to Mr. Paul?
There was an attorney who was representing Nate Paul, who provided information, our understanding is provided information to General Paxton concerning Brandon Kamek. That attorney, we understand, represented Nate Paul.
Any idea how much outside counsel was paid?
There was a budget set aside for $25,000, is my understanding.
Thank you.
And I know we're a little pressed on time,
Nope.
so I'll go.
You take your time.
Very good.
Please continue with explaining to us how I think where we last interrupted you with questions is that a determination had been made by General Paxton to arrive at retaining Mr. Kamek as some
Kamek.
type of outside counsel.
That is correct.
Walk us through that. Well, and Jim,
I don't want to stop this, but there's no, this committee has permission to meet while the House is in session. Is that correct?
on May 1st, 2023, permission was granted to the General Investigating Committee to meet while the House is in session. While the House is convening today at 10 a.m., the committee will continue to hear invited testimony.
Okay, so there's no reason for us to shut off at 10 o'clock.
That is correct.
I plan to leave about 10 to 10, get his gaveled in and come back if that's okay with the chair.
Absolutely, Mr. Speaker.
Thank you, sir.
Please continue.
Thank you. As directed by Attorney General Paxton, a draft contract is developed by Mr. Vassar, who takes it upon himself to limit the scope of the investigation. In other words, he is allowing for the contract to authorize investigation only and exclude prosecution. Vassar, despite his reservations, signs that limited contract in the approval chain on September 15th, 2020. Senior staff members along the line of authorization previously discussed refused to approve the outside counsel contract because there was, in various opinions, no valid matter for investigation, and it is further against prosecutorial ethics to proceed with an investigation that lacks merit. Additionally, it was their opinion that Kamek, even if a valid investigation existed, was not qualified to handle the investigation.
Chairman
Thank
Longoria.
you, Chairman, and I hate to interrupt you, Mr.
Please.
Donnelly. So how would anyone even know that the AG's office was seeking outside counsel? I mean, was this posted like on Craigslist? I mean, I'm just trying to get my head wrapped around
I think
this.
oftentimes, and I can't speak to, I don't want this to be taken as gospel of the way that it normally occurs, but oftentimes known attorneys are vetted for various positions, those who might have expertise in a particular area, those who might be particularly suited for a contract. Those individuals are vetted, the contract is developed, and then it's taken up the chain.
And you mentioned, I think there was 2 individuals that were interviewed as possible outside counsel. And the first one, had he or she served as outside counsel before? The one with the decades of experience?
That's a question that I don't know the answer to.
Okay.
I apologize.
All right. And the other individual was not the one that was ultimately hired. He had never served as outside counsel in any type of capacity.
That's my understanding.
All right.
And please don't apologize for interrupting me with questions. That's what we're here for. Thank you. So again, the senior staff members had refused to approve the contract. Mr. Penley explained to General Paxton again that outside counsel was not needed, that there were ample in-house assistant attorney generals who could review the complaint. He further pressed that even though they had advised that there was no criminal conduct that they were able to see, that they would continue to review the complaint if Mr. Paul provided all documents to support his claim. On September 23rd, 2020, Mr. Kamek called the Office of the Attorney General and asked for something official to show that he was working for the Office of the Attorney General. He was told that his contract was not approved. General Paxton contacted Mr. Vassar and asked why the contract was not approved. At this same time, Don Clemmer of the Travis County District Attorney's Office Special Prosecution Unit had sent Kamek the second Nate Paul complaint. Per the Office of the Attorney General, the second complaint, again on that general form that we discussed earlier for gathering information that does not confer a direct investigation with the Travis County District Attorney's Office. The second complaint is not referenced in any internal Office of the Attorney General databases or emails of which we are aware. The next day, on September 24th, 2020, General Paxton called and told Penley to sign the contract. Penley again refuses because the Office of the Attorney General cannot investigate what has become aware to him as federal judges, an assistant United States attorney, or others who might be involved in a federal investigation.
I'm sorry. Can you say that again?
Yes. Penley refused to sign the contract because he had advised that the Office of the Attorney General could not investigate the federal officials who Nate Paul complained were involved in this as part of his complaint.
So the Brandon Kamek is being hired off the books to use the Office of the Attorney General to investigate the potential federal officials and court officials who were looking into Nate Paul.
There were 2 complaints, one of which involved financial dealings with Nate Paul, and the other involved the FBI raid and a search warrant on his home and businesses. And I want to be clear, if I may. I don't want to say that the contract was off the books. It was a contract that was authorized by the Attorney General, completely outside of the norms, but it was one that was authorized by the Attorney General, and one for which a budgeted amount was set aside.
Mr. Spiller.
Thank you, Mr. Chairman. Briefly, and you may have touched on it, Mr. Kamek, I think you've said he was an attorney with 5 years of experience. Is there any indication that he had any prosecutorial experience whatsoever?
None.
Thank you.
Just to also clarify, at this point, there are other people in the OAG's office that recognize that this person is being hired to conduct an investigation into the feds, and they say, hey, we're not doing this?
I just want to be clear with my words. There are not others who are aware that he's been hired. There are others that are aware that there is this contract potentially being floated for approval as outside counsel, and they disapprove.
And do they know that the outside counsel is being brought in for the purposes of trying to go after the feds?
It's my understanding, and I believe through our investigation, we would establish that several did know that the substance of the investigation dealt with those matters.
And they are not in support of this, is that right?
We did not find an individual we spoke to who was in support of this investigation.
Chairman Longoria.
Thank you, Chairman. I'm going to be jumping ahead of myself, but did Kamek produce any work product? Was there anything done?
There were some things done, and I will cover those in just one moment. And I appreciate your patience on it. Again, Penley has refused to sign the contract on September 24th, 2020. And again, to your point, Vice Chairman Johnson, at this point, several senior staff members had expressed concern about the substance of Nate Paul's complaints, about Nate Paul himself, and about any contract for Kamek to work, to perform any work. And as no contract at this point had been signed or approved through normal procedure, there was a belief that no action had been taken. General Paxton, however, continued to pressure staff to approve the contract. On Saturday, September 26, 2020,
Probably want to get some images of these devices right here. Okay. This is how they were stealing the fuel. Oh, awesome. Using these types of devices, they're homemade devices that they make with the purpose of powering it remotely or directly. This slows down and speeds up the speed on it, turns this little motor, and this is hooked to the measuring device within the pump. Oh, you'll be referring to those while you see everything. We'll talk a little bit about it. I'll provide y'all pictures and some PowerPoints that go out with the press release that explain it further. But it basically, and I can answer any questions after we're done with our little spill. I can answer any questions that you guys may have. Okay. Well, this will go out with the press release that we have. Yes, I'll show you the next page here. And that's going to be after your tour? Yeah. Okay, awesome. showing some please. And then you guys will get this. I get over this that has those devices. That's actually the measuring device. And that's how it hooks up. So when you talk about it, it's so much easier to manipulate and use things like that. Right. And kind of zoom in. Yes, sir. Yes. He said they're also in the press release. You gonna ask him right now?
No, it's not good. Oh, after.
Yeah, I guess if anybody else needs it, then I can do it for everyone. You know, we might have others showing up. Be nice not to have to do it 5 times.
Yeah.
You ready to get started, sir?
No, sir, I'm just getting my stuff up
Oh,
here.
okay.
I'm just making sure I got room and everything I need and. I'm just the, here it is. I'm not running this program.
All right. You got all the stars. Looks like you.
Well, it's like I tell them, I'm like the behind the scenes kind of guy. I don't like being out in front.
Right.
So it's just,
But 4 stars, that means the chief, right?
yes.
Okay.
That means I have to be out front, whether I want to be or not to be.
That's the way it is sometimes.
the only ones that we would trust to talk to, and everybody else, pretty much broken up in it before. I talked to Courtney, she was gonna be here, said they already had somebody working on something in Huntsville.